Mr. Speaker, the measure before us today has been introduced by the gentleman from California, a ranking member of the committee and a subcommittee chair, Howard Berman. And it is intended to restore the historical checks and balances to the process by which interim U.S. attorneys are appointed. It will repair a breach in the law that has been a major contributing factor in the recent termination of 8 able and experienced United States attorneys and their replacement with interim appointments. It has gathered much attention across this nation, and not just in government and legal circles. The full circumstances surrounding these terminations are still coming to light. But what we know is already very troubling. The reports about these terminations are particularly troubling in that the United States attorneys are among the most powerful government officials we have. They have the power to seek convictions and bring the full weight of the United States government against any citizen or company that they deem important and eligible for prosecution. They can negotiate plea agreements. They can send people to prison for years and years. And frequently, the mere disclosure of a criminal investigation can destroy reputations and careers. These are awesome powers. And so we on the Judiciary Committee consider it absolutely essential that the American people have full confidence in those entrusted to exercise these powers, and that they do so with complete integrity and free from political influence of any kind. The committee's investigation into these troubling circumstances is continuing, and the longer time goes on, the more we know. And the more we know, the more we're troubled about what has been going on in the Department of Justice. But it has already become abundantly clear that the gaping vulnerability in the law, which has placed the independence and integrity of our prosecutorial system in jeopardy, needs to be repaired as quickly as possible. And that's what we are here to do today. What helped bring these troubling circumstances about? What helped make it possible for high-level Justice Department and White House officials to even entertain the notion that they could, as appears to be the case, target certain U.S. attorneys for an unprecedented mid-course purge was an obscure provision quietly and anonymously slipped into the USA Patriot Reauthorization Act conference report in March of 2006. Without any debate, let alone the benefit of a single hearing in either body, this provision, added at the behest of the Justice Department's top political appointees, to significantly enhance the power to appoint interim U.S. attorneys without having to subject their appointments to customary safeguard of Senate confirmation. It was a middle-of-the-night insertion, and we are here to correct that. Indeed, the administration's plan to exploit the new provision to bypass the Senate confirmation process is now well documented, as bluntly explained by internal emails we received, and they now number in the hundreds, although we get them late on Friday nights, by the Attorney General's then Chief of Staff, for example, discussing their plan to install the former Republican National Committee political operative. The new provision would enable them to, quote, give far less deference to home state senators and thereby get our preferred person appointed and do it far faster and more efficiently at less political cost to the White House. This is outrageous. The Senate has already acted. The time is now. We need to move as rapidly as we can to correct this very serious error that casts a question upon the integrity of a very, very important part of our government, the Department of Justice. Mr. Speaker, I reserve the balance of my time.
The gentleman reserves. Gentleman from North